As congressional investigations on both sides of Capitol Hill continue, the Senate Judiciary Committee held a hearing examining the role of special counsels and separation of powers. Many of the questions from committee members centered around Robert Mueller, the special counsel who is investigating Russian interference in the 2016 presidential campaign and potential collusion between Russian operatives and the Trump campaign. This runs 2.5 hours.
Before we have our opening statements for this hearing, I have a short statement I want to make on another issue, and if Mrs. Feinstein has anything on the same thing I'm talking about, she would get whatever time she wants. Separate from my regular opening statement, I need to talk about a serious threat to this committee's oversight authority and do it just briefly. The need for Congress to have access to information in the executive branch is inherent in the Constitution. The Supreme Court has said so clearly and repeatedly. Executive branch agencies cannot limit our legislative power of inquiry merely by entering into non-disclosure agreements with one another. But that's exactly what the FBI has tried to do. Yesterday, I sent a pair of letters to the Office of Special Counsel and the FBI about the most recent example. Non-disclosure agreements are essentially gag orders, plain and simple. They thwart transparency, accountability, and seek to obstruct congressional oversight. The Office of Special Counsel, OSC for short, is a permanent independent watchdog agency, not a temporary prosecutor appointed by the Justice Department like Mr. Mueller. Following complaints from Congress, the Office of Special Counsel opened an investigation of former Director Comey. By law, one of the Office of Special Counsel's jobs is to enforce the Hatch Act. The Hatch Act makes it illegal for government officials to engage in political activity. So the Office of Special Counsel began trying to gather evidence to find out whether Comey had a political motive for his actions. But there was one problem. The FBI refused to cooperate voluntarily. OSC could have engaged in a long legal battle to force the FBI to turn over the information. But the FBI was apparently less concerned about OSC than they're concerned about Congress's oversight opportunities and responsibilities. The FBI demanded that OSC promise not to give any of the information to Congress. A gag order, that was the price of quick and easy access to the information by that agency. So OSC took the deal. But the documents and interview transcripts are vital to this committee's oversight of the FBI. We managed to obtain 2 heavily redacted witness interviews. They show that Mr. Comey had made up his mind and started drafting his controversial announcements months before the Clinton investigation was over. But we were not consulted or even informed of the FBI's insistence that OSC agree to a gag order until after the fact. According to OSC, the FBI has never asked for such a gag order before. Neither has any other agency. Why now? Why was the FBI so focused on keeping Congress in the dark? Why is it so afraid of shining the light of day on the controversial decisions Mr. Comey made in the months before he was fired? This isn't the first time the FBI has tried this trick. It also reportedly made all the agents working on the Clinton investigation agreement agree to a special gag orders. But the executive branch cannot avoid constitutional oversight by assigning agreements. This committee has oversight authority over the Department of Justice and the FBI. if there's any whiff of inappropriate partisan or political influence in these institutions under any administration or any party, this committee has a duty to get to the bottom of it. That is exactly what we will do. I expect full, complete, and timely answers to my letters. This committee needs to see the full witness interview and all the documents, including drafts and internal FBI memos about Comey's decision to make that controversial statement last summer, and I will do everything in my power to make sure that we do. Do you have anything you want to say on that subject? Because you can have whatever time you want.
Well, thank you very much, Mr. Chairman, and I'm in agreement with the general thrust of your statement. I have found that it should also apply with the sharing of intelligence with this committee, and I have sent a letter to Senator Burr. As a member of the Intelligence Committee, I have been privy to certain pieces of intelligence, as would Senator Cornyn be privy to that. It seemed to me that when I saw it, it was relevant to this committee's oversight, and yet this committee cannot receive it. So I have sent a letter which documents our rules, and hopefully the Intelligence Committee will be responsive, and that matters that involve our oversight, which, as we've discussed in the investigation, there's clear oversight of the Justice Department, and therefore matters of obstruction of justice are within the jurisdiction of this committee. And so hopefully we will be able to obtain that. I just haven't had a chance to tell you that, but I did it. Thank you.
Welcome everybody to this very important committee meeting and hearing that has very basic constitutional issues that are connected with it. We have an outstanding panel to help us go through this. So today's hearing will hear testimony related to two bills recently introduced by members of our committee. 1735, introduced by Graham, Whitehouse, and Blumenthal, as well as their members of the committee, as well as Senator Booker, who's not a member of this committee, and 1741, introduced by Senator Tillis and Coons. These bills have some things in common. Each bill attempts to codify current DOJ regulations about removals of special counsel. Each bill provides for judicial review of removal decision, and each bill has bipartisan support. It is also clear that each bill is motivated by similar concerns about the current special counsel, Robert Mueller, and his investigation into the Russian government's efforts to interfere in the presidential election. One of the bills even specifies that it applies retroactively to the date of Robert Mueller's appointment. And both bills were introduced when media speculation was rampant that President Trump was contemplating firing Mueller. The president has said that he does not intend to fire Mueller, and I think that he made the right decision. I hope that this investigation proceeds to its conclusion rapidly and stays focused on what Deputy Attorney General Rod Rosenstein charged it to investigate. The American people can be sure that this committee, which has jurisdiction over DOJ, FBI, etc., will take its oversight role over the investigation as seriously as I think this committee has a reputation for doing. While there is no doubt that current events are significant to the issues we discussed today, it is my hope, sincere hope, that during today's hearing, the committee will engage in a broader discussion of the grand tradition of the Senate as a deliberative body. Both of the bills we will discuss today raise potential separation of powers concerns that I believe deserve the attention of the committee and respectful discussion of it. The issues that we discuss today are bigger than the president or any of us. They concern the fundamental design of our republic. When they drafted the Constitution, founders of this nation were rightfully concerned that those in power would be tempted to abuse it to favor their own interests. To prevent this, the founders divided power among the three branches of government that I don't have to reiterate, but James Madison put it this way in Federalist 51, quote, "Ambition is made to counteract ambition." It is through, end of quote, it is through this system of checks and balances between the ambitious branches of government that our fundamental liberties are protected. There are those who argue that the rise of the modern administrative state with its federal agencies that are vested with both executive and legislative powers and even judicial powers sometimes have weakened the separation of power provisions of our Constitution, or at least changed how we should understand them. I believe that our government works best when each branch of government has a clearly defined role, and I think that even in our modern times, with our greatly expanded federal government, that is not too much for us to hope for. But it is something that we as members of Congress must carefully consider as we looked at this drafted legislation. Some who agree that these bills are good policy argue that by codifying the DOJ special counsel regulations and providing judicial review over removal removal decisions, they provide useful certainty about how disputes over the removal of a special counsel would proceed and afford the office of special counsel needed independence. But there are others who argue that these efforts run afoul of the Constitution by interfering with the President's ability to control the executive branch and to make sure that the laws are faithfully executed. I hope that both those who view these bills as constitutional and those who express their doubts that they're constitutional can agree on one thing. There is a robust role for Congress in overseeing the executive branch, including all investigations conducted by the Department of Justice appointed special counsels. The American people also play an oversight role and can apply political pressure to any president who removes a special counsel for reasons that they do not consider adequate. Finally, the Constitution gives Congress the ultimate check on the executive branch through the power of impeachment. Every American has a right to expect their government to be ethical, effective, and accountable. If there is one thing that I've learned in my career as both a farmer and as a senator, it is that where the sun pokes through, there can be no darkness. I have spent my career as a strong advocate for openness and transparency in government, but I also believe that the separation of powers is essential to preserve the liberties that we Americans enjoy. I look forward to today's hearing. Senator Feinstein.
Thank you very much. Let me, if I might, Mr. Chairman, start with a correction of my earlier remark. The letter I mentioned on the intelligence sharing with this committee was sent to the director of the CIA, Mike Pompeo, and was signed by both the chair and ranking member of this committee. We sent it yesterday, and I'd ask that it be incorporated in the record.
It'll be in the record.
Thank you very much.
Without objection.
And thank you for calling this hearing to address the two bipartisan bills to protect the integrity of the special counsel. Today, under current Department of Justice regulations, the special counsel, as everybody knows, cannot be fired for anything but misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause. Those regulations have been in place since 1999 and were meant to ensure integrity and impartiality when Department of Justice has a conflict of interest. They have been in place during both Democratic and Republican administrations, and neither their necessity nor efficacy has ever been seriously questioned. Both of the bills we are considering today provide extra layers of protection for the special counsel. They were introduced on the heels of reports that President Trump was contemplating firing special counsel Bob Mueller, a man who has broad bipartisan support and who has served this country with honor and distinction. I think my colleagues from both parties agree that firing Mueller would be a grave mistake. For example, Senator Graham, star of stage, screen, and radio now, has said that unless Special Counsel Mueller did something wrong, firing him, and I quote, could be the beginning of the end of the Trump presidency, end quote. And Senator Markey has gone so far to say that doing so would be, quote, a full-blown constitutional crisis. Firing Special Counsel Mueller would be that much more concerning, given widespread understanding that individuals close to the president, or even the president himself, have tried to tip the scales of the Russia investigation. We've all heard President Trump's reaction when Attorney General Sessions recused himself from the Russia investigation. Even though the Attorney General acted properly, the president berated him because the recusal led to the appointment of the special counsel. Several months ago, we also heard from former FBI Director James Comey, who testified before the Senate Intelligence Committee that he felt pressured by the president to, quote, let Flynn go, end quote, and to, quote, lift the cloud, end quote, even though an FBI investigation was ongoing. Simply put, I have strenuous concern about President Trump's respect for the rule of law. The president must know that Congress will not stand idly by if he attempts to undermine independent criminal investigations. Turning to the bills themselves, first, they both require good cause before the special counsel may be removed. This means that the Attorney General could not fire the special counsel absent some sort of misconduct, illegal act, or violation of Justice Department policies. Secondly, if the Attorney General finds good cause to remove the special counsel, both bills allow a court to review that finding. The two bills differ a bit. The bill introduced by Senators Graham and Booker and co-sponsored by Senators Whitehouse and Blumenthal would require a court to determine that good cause exists before the removal of the special counsel. And the bill introduced by Senators Tillis and Coons would allow the special counsel to ask a court for reinstatement after the fact if the removal was not for good cause. That bill also provides that if the Attorney General is recused, only a Department of Justice official confirmed by the Senate could fire the special counsel. We are joined today by a panel of distinguished legal experts, and I very much look forward to this discussion. I expect much of it will cover Supreme Court precedent and whether the precedent applies to today's situation. While precedent is certainly important, excuse me, in this discussion, I'm hopeful that we won't let a discussion of legal theory prevent us from speaking about the real-world problems these bills address. We are aware that in 1973, President Nixon wanted to fire Special Prosecutor Archibald Cox, who was conducting the Watergate investigation. But the Watergate Special Prosecutor could only be removed by the Attorney General, and only for good cause. Nixon's order to fire the special prosecutor led to the Saturday Night Massacre and resignations of Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus, who both determined there was not good cause to fire Cox. Although Cox was ultimately dismissed, it was not before two Justice Department officials had sounded the alarm on President Nixon's interference with the investigation. That is proof that protections like the ones we are discussing today are not only necessary, but they also work. If past is prologue, what we are discussing today could not be farther from being merely theoretical. With that, I will turn to the chairman.
Thank you. Senator Feinstein already referred to our panelists as distinguished panelists, and I've noted, my staff has noted for me, all the publications you've all done. And if I refer to every one of those publications, you'll never get a chance to give your remarks. So I'm going to give a relatively short introduction of each of you, but you can go to the record. Everything that is in my opening remarks will be in the record, so you know that I have absorbed that you are all well published and very distinguished in your professions. Our first witness is Professor Akil Reed Amar, Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law. He has also won awards from the American Bar Association and the Federalist Society, and is a recipient of Yale's highest award for teaching excellence. He has been favorably cited by the Supreme Court in over 30 cases. And then he has authored dozens of law-reviewed articles that I'm going to put in the record. Our second witness is Professor Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law, University of Chicago. He writes about and teaches legal theory and constitutional law, including the law of presidential powers. He has written more than 100 articles at academic journals and more than a dozen books, including 2 of the presidential power, one entitled The Executive Unbound, After the Madisonian Republic, and then he's published in various important newspapers and other articles, and those will be put in the record. Our third witness, Professor Stephen Vladeck, professor at the University of Texas School of Law. Senator Cornyn, I hope you weren't, I was going to introduce these folks. Was I supposed to give deference to you?
No, sir.
Okay.
Go ahead, Mr. Chairman.
Professor.
I'm glad to have somebody from the University of Texas Law School here today. We discussed FISA reauthorization in the line at Southwest Airlines yesterday in Austin. So I'm glad to have him here. Thank you.
Professor Stephen Vladeck, a professor at the University of Texas School of Law, where he teaches federal jurisdiction, constitutional and national security law. His works have appeared in a variety of news forums and legal publications, including Harvard Law Review and Yale Law Journal, and the rest of that will go in the record. Our final witness, Professor John Duffy, Samuel H. McCoy, Professor of Law, and Elizabeth D. and Richard A. Merrill, Professor of Law at the University of Virginia Law School. He teaches tort, administrative law, patent law, and international intellectual property law. He has also served as articles editor for the University of Chicago Law Review, and was awarded the Olin Fellowship in Law and Economics. Professor Duffy, clerk for Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit, and for Scalia, served as attorney advisor in the Department of Justice Office of Legal Counsel, and practiced law at Covington and Burlington. He has also published much. The committee has also received a letter from Professor John Harrison, the James Madison Distinguished Professor of Law at the University of Virginia Law School. In it, Professor Harrison expresses his views that both of the bills that we are considering today would encounter significant constitutional difficulties, and that letter will be put in the record. We'll start with you, Professor Amar.
Thank you, Mr. Chair. It's an honor to be with you all. I've previously testified before this committee on